Hey everyone, Ashley Abraham here, litigant defense attorney and former DUI prosecutor. Today, I want to address an important and often overlooked aspect of DUI convictions, how a DUI can impact child custody arrangements. This is especially relevant for parents who are either currently involved in a custody case or who may face one in the future. Let's get into what you need to know if you're facing a DUI and have concerns about how it could affect your relationship with your children. First off, let's talk about the immediate impact. A DUI arrest alone can raise red flags in family court. Courts view DUI as a serious offense because it implies that someone may make unsafe decisions, especially decisions that could potentially endanger others, including children. In Tennessee, if you're arrested for a DUI and have custody or visitation rights, the other parent might raise concerns about your ability to safely care for the child. If you're going through an ongoing custody case, the DUI could influence the court's decisions, especially in terms of who has primary physical custody, parenting time, and even legal decision-making authority for the child. Now, let's look at how a DUI conviction, not just an arrest, might affect a custody case. Tennessee family courts make custody decisions based on what's the best interest of the child. A DUI conviction can be seen as evidence that a parent may lack good judgment, which could directly impact a custody arrangement. In particular, a judge may consider the following factors. Number one, risk of harm to the child. The court's main concern is whether the parent poses a risk to the child's safety. A DUI conviction can lead the judge to question whether it's safe to leave a child in the care of a parent with a history of impaired driving. This could be especially damaging if the child was in the car at the time of the arrest, which could lead to additional charges and increased scrutiny in court. Not to mention, a DUI with a child in the car at the time carries a mandatory 30-day jail sentence. Number two, it's a demonstration of poor judgment. Courts view a DUI as evidence of poor judgment, which is a critical quality when evaluating a parent's ability to make responsible decisions for their child's well-being. Number three, potential for repeated behavior. If it's a second or subsequent DUI offense, this might signal a pattern of risky behavior. In such cases, the court could interpret this as a sign that the parent might struggle to prioritize their child's safety over their own actions, leading to more stringent custody restrictions. Now let's talk about how DUI charges can be used in custody modifications. Another important point to understand is that even if you have an established custody arrangement, a DUI conviction can open the door for the other parent to request modifications. If the other parent feels that the conviction demonstrates a change in your ability to safely care for the child, they can petition the court for an adjustment in custody or visitation rights. The modifications they may request could range from limiting your visitation time to requiring supervised visitation. In some cases, a parent with a DUI conviction may be ordered to complete alcohol treatment programs or parenting classes before regaining unsupervised access to the child. Let's discuss mitigating the impact of a DUI on custody. If you're facing a DUI and are worried about the impact on your custody rights, it's important to take proactive steps to demonstrate that you're committed to being a responsible parent. Here are some things that you can do to mitigate the potential fallout. Number one, complete a substance abuse program. Enrolling in a DUI or substance abuse program voluntarily shows the court you're willing to take steps to address any potential issues. Courts are generally more lenient towards parents who demonstrate a willingness to improve and who show accountability for their actions. Number two, provide proof of a safe parenting practice. Document your positive interactions with your child, maintain consistency with your visitation schedule, and demonstrate a stable and supportive home environment. Any additional evidence of responsible parenting can help counterbalance the DUI conviction. Number three, consider counseling or therapy. Attending therapy, especially if the DUI is part of a larger issue, can demonstrate that you're making an effort to address the underlying causes of the offense. Judges often look favorably on parents who take proactive steps to improve themselves, especially if it's directly related to creating a safer environment for the child. If you're facing a DUI while involved in a custody case, it's essential to work closely with both your criminal defense attorney and a family law attorney. Having an experienced defense attorney on your side can help you reduce the impact of the DUI charge, potentially negotiating for reduced penalties or alternative sentencing that may have less influence on your custody case. Meanwhile, a family law attorney can help present a strong case to the court that your DUI does not affect your ability to parent responsibly. So, to sum it up, while a DUI conviction can impact child custody arrangements, The effects don't have to be permanent. Courts want to see that parents are taking responsibility and actively working toward creating a safe environment for their children. If you're facing a DUI charge and are worried about the impact on your custody situation, reach out to us at Litson. We'll help you take the necessary steps to protect your rights as a parent and ensure you're making the best case for your relationship with your child. Thanks for tuning in, and remember, stay informed, stay safe, and never underestimate the importance of good decisions, especially when it comes to your kids.